Our clients often ask us, what are the most important business terms they need to include in a cloud contract? My name is Marcus Harris. I'm a software and intellectual property attorney. I focus my practice for the last 20 years on drafting and negotiating technology-related agreements, software licensing contracts, SaaS agreements, and litigating failed software disputes in courts across the country. I think when you're negotiating cloud agreements from a business perspective, there's really three things that you need to focus on. And the first one, I think, is securing significant discounts off of the list price. And I think the discounts need to be associated with the volume of software that you're buying and the length of the term. Obviously, the more software that you're buying, I think the bigger the discount off the list price should be. And certainly if you're going to license software for any significant term, whether that's 3 years, 7 years, or beyond, I think you need to be compensated for doing that by getting a bigger discount than you otherwise would if you were negotiating on a 12-month basis. One of the other issues that you really need to focus on is price protection. I think vendors are very happy to renew your term automatically for subsequent years, subsequent terms, and what goes hand in hand with that often is a significant jump in the price that you're paying for the underlying SaaS product or software. And I think on the front end, you really need to think about minimizing your cost outlay, and you have no better time and no better leverage to be able to do that when you're negotiating with your vendor initially. And the way to do that is really to think of what kind of cap are you going to include for the duration of that initial term, and certainly for subsequent renewal terms. And that can look like anything from percentage of the total fees that you've paid for that initial term, a percentage of the fee that you paid in the last year. It can be a cap associated with CPI, plus a number, +5, for example. Whatever it is, it needs to be objective, and there needs to be some sort of a cap on the vendor's ability to increase fees going forward. The other thing that I think you really need to focus on from a business perspective in a SaaS agreement is transition assistance. I think vendors know that once you get signed up on their particular product, it's really hard for you to transition away from that. And for whatever reason, if this particular SaaS product is no longer serving your needs and you need to terminate either for convenience or certainly for cause, you want to have the ability to be able to get your data out of that in a clear, organized, and efficient way that's not going to cost a lot of money. And again, on the front end, when you have leverage, it makes sense to put some sort of a provision in these agreements that accounts for what I would call transition assistance. And that can look like anything from the vendor is going to help you take your data out of that system for a period of 6 months for a particular fee, or you're going to have access to it while you're transitioning to a new system. Whatever it is, you want to make sure that you've got some flexibility with getting away from that legacy system to your new system. And so I think if you focus on some of these business issues, you're really going to do yourself some good service in mitigating risk and maximizing your flexibility with your relationship with the software and with the vendor. If you have any questions about anything that we've talked about in this video, or you're having any difficulty in negotiating with your SaaS vendor, feel free to reach out to us at taftlaw.com. We're always happy to talk to you about the contract negotiation process and issues that come up and how to navigate that process.